Yes. He also has a funnel under TRC.
Okay.
There's two. Repeater. We're. Next.
I have the bullet casing in the street from the shotgun shell.
Okay. All right. Who is the persons on Luis Hernandez? All right. You want to see if your client's in the hallway? Thank you.
Yeah, about that, because I was, we had talked about it. I didn't want you to think I was going anal.
No, not at all. No, I appreciate it.
Oh,
Very calm.
Okay.
one of the things that they did with the AUC. It's called me on.
No,
Anyway.
I appreciate it.
Oh, and Surgeon,
Mhm.
that one,
Okay, yeah, absolutely.
yeah. All right.
On which one?
If we-
Oh, yes. Yep. Sounds lighthearted. Casual day in the office.
Judge.
My phone.
Martin Waffles.
Mhm.
Oh, you went.
Yes.
Oh, okay.
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 Awesome. Awesome. Responding. Awesome.
All right. Could I see the violation report on Nicholas Vaquera, please?
He's in the elevator on the way.
All right. Thank you. He's on the add-on.
I mean, yeah, let's see if I can put it on. It should be in the files.
Oh, it's not indicted.
Yeah.
It's not indicted.
Yeah, no, he has it in the files.
Okay, it's in there, it's all in there.
Hi.
Okay, they're all ready to go for it.
All right. Thank you.
You're welcome.
And then what, if you don't need them, you can send them home. We don't need them back. That's.
All right. Thank you. And Norma? Anthony Cantrell, where is he?
He said he'll be here by 1:15. I told him he was coming in during the lunch hour and I saw him come back.
No, that was printed on the thing and I was was for. What is it?
There's something I was just saying. Oh, no.
Mr. Hernandez is present.
All right. If you'll come forward.
Which side am I on?
You're on this side and your client's in the middle.
So you're on.
Are you ready to go on the record?
No.
Court is calling 2023 CR 9087 and 9088, State of Texas versus Luis Miguel Hernandez. Can I have parties announced for the record for the state? Defense.
Hernandez for the defendant, Luis Miguel Hernandez.
And are you Mr. Luis Hernandez? Counsel, have you received all the discovery in each of these cause numbers and did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. And each of the cause numbers, I'm showing you what's entitled application for probation. Did you review those with your attorney? Did you understand them and did you sign them?
Yes, Your Honor.
And each of the cause numbers, I'm showing you what's entitled true bill of indictment. Did you review those with your attorney? Did you understand them?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment in each cause number?
We do, Your Honor.
State, are you proceeding on the indictment as presented in each cause number?
Yes, Judge.
All right, Mr. Hernandez, in each of the cause numbers, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review those documents with your attorney? Did you understand them?
Yes, Your Honor.
And the cause number ended in 9088, you're charged with the offense of possession of a controlled substance, penalty group 1 less than 1 gram. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. And cause number 2023 CR 9087, you're charged with the offense of possession of a controlled substance, penalty group 1 gram to 4 grams. That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
And each cause number, if you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent. Did you understand?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
As to both charges, yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, yes, Your Honor.
Mr. Hernandez, in either cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
And each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. And each of the cause numbers, I'm showing you the plea bargain agreement. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement. All right, everyone, you need to whisper. According to the plea bargain agreement and cause number ending in 9088, punishments be assessed at 2 years in the state jail facility. And the cause number ended in 9087, punishment is be assessed at 10 years in the prison. The state is recommending community supervision. The cases will run concurrently and cause number 2023 CR 9089 will be taken in consideration. And there's a request that you be referred to drug court. Did you understand that that's the plea?
Yes,
Defense, is that the plea?
it is, Your Honor.
State, is that the plea?
Yes.
Showing you in each cause number, the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions
Your Honor.
outside the agreement? And cause number ending in 9088, state is requesting that your community supervision be for a term of 5 years. And the cause number ending in 9087, state is requesting that your community supervision be for a term of 8 years. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then in the cause number ending in 9087, how do you plead? Guilty, not guilty, or no contest?
No contest.
And in the cause number ending in 9088, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea?
The state offers dates to the one in both cases.
Any objections?
No, Your Honor.
And state just one moment. Mr. Hernandez, in each cause number, did you review the documents entitled waiver and consent, the stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
And each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Thank you. And Ms. Abrams, this is Luis Miguel Hernandez.
Thank you.
All right, after reviewing states exhibits 1 and attachments in each cause number, the court will find there's sufficient evidence to find you guilty. The court will defer finding of, I'm sorry, you didn't apply for deferred adjudication. So on each cause number, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, we would ask done today.
Anything you wish to say on behalf of your client?
Yes, Your Honor. Part of the reason he accepted probation and the reason the state has extended an offer of probation, he has been treating a methadone clinic with the Center for Healthcare Services since March of 2020. That being said, he did admit on this date that he did have a setback. He's been clean since that time and continued to treat with the methadone clinic. We do believe that probation is an excellent opportunity for him to remain sober. He does receive Social Security disability income, is that correct?
Yes, sir. Disability and SSI.
I'm sorry, you're going to have to speak up so the court reporter can hear.
I'm sorry, I said SSI and disability.
He's receiving Medicaid, so we just asked the court to consider that in sentencing him today.
All right, why are you receiving SSI?
I got a schizoaffective disorder and PTSD. Sure.
All right, so how often are you using? And here's the thing, you need to be honest with me because I've read the police reports and each time with the police reports, you were passed out and they had to use Narcan to revive you. So that's very dangerous.
I mean, I've been doing good lately, but I mean, my thing is, you know, when I get really stressed out and like, you know, depressed because my bipolar and stuff, I tend to run to that, you know what I mean? And I'm working on it and I know it's not right and I'm trying to.
So when's the last time you used?
Last time?
Was it yesterday?
No, I mean.
Because I will have you direct.
Yes,
No.
Marijuana?
We're not talking about marijuana.
Oh, yeah, it's been a long time.
So if you're drug tested today, what are the results going to be? And there's someone here to drug test you today.
Marijuana, maybe some methamphetamine.
All right, anything else?
That's it.
So when's the last time you used?
You talking about the opiates?
Mm-hmm.
Oh,
Opiates, the fentanyl, the heroin.
oh, that was my first and last time, only time doing fentanyl, honestly.
All right.
But my thing is heroin, and that was since then I've probably done it one time, to be honest.
And the meth?
Oh, the meth, that's just like it's around, you know what I mean? Because my mom is on that stuff, unfortunately. But probably like it's just bad habit that I might hit it and like maybe once a month or something. All
right. And cause number, do you have children?
No, ma'am.
Okay. And cause number 2023 CR 9087. Court is going to sentence you to 10 years in the prison, suspended and probated for 8 years. This will run concurrent with 2023 CR 9088. Take in consideration 2023 CR 9089. There's going to be referral to felony drug court. And that's going to be in custody. Regular reporting by Zoom or in person. UA hotline until further notice. Proof of employment or SSI within 60 days. So you have to provide proof of that.
Yes, ma'am.
There's to be no employment as a home health care provider or with minors. 90 sober meetings in 90 days. Field visits 1 time per month until further notice. $200 hours of community service restitution. Probation, is there anything else needed in that cause number?
No, Judge.
And cause number 2023 CR 9088, court is going to sentence you to 2 years in the state jail facility, suspended and probated for 5 years. Take in consideration 2023 CR 9089. This is to run concurrent with 2023 CR 9087, referral to felony drug court in custody. Proof of employment or SSI within 60 days. No employment as a home health care provider or with minors. Regular reporting by Zoom or in person. UA hotline until further notice. 200 hours of community service restitution, 90 sober meetings in 90 days, field visits 1 time per month until further notice. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement in each of these cause numbers, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Sure.
All right, we're going to go off the record. Mr. Hernandez.
Just quick on the record,
Oh, on the record.
Is he allowed to purchase those community service hours just because of his disability, or does he have to find some place to perform that will take into consideration?
Oh, I think they'll find a place for him.
Very well.
And usually with felony drug court, they will actually, they're very creative with the community service hours as to doing things that can help you. So they may waive some of your community service hours if you go on a retreat. All right. Off the record. So let me just tell you why you're going in custody. The reason why you're going in custody is because you're continuing to use, and being on methadone plus using other drugs is not good. And in each of these police reports that I read, you were passed out. And in one police report, you had overdose and they had to use Narcan to revive you. You could have died.
But you
And
can look
then-
at my UAs at the clinic, and I don't use heroin.
No, I mean, the problem is you're using other thing than just heroin. You're using meth. So, you really can't trade one drug for the other.
I mean, I don't use it all the time.
So this is what's going to end up happening. We can go off the record. This is, your attorney will talk to you. I'm going to reach out to felony drug court if you don't have a problem with that, counsel.
None.
And see if they can interview him this week, because I think he needs to be in there quickly. And I will send an email to them to see if they can accept him, explain the situation to them. And you need to be honest with them. Don't be like, oh, it's just marijuana or it's just this. No, you need to be very honest with them. All right. And Miss Abrams, also, can you do a, he probably is going to need a MIC eval as well. Yes. Okay, thank you. All right, thank you.
No, I'll just these, okay?
Yeah, that's fine. I think felony drug court will accept him. Can you please, I'll send an email as well to felony drug court.
referral for phone job. Oh.
Yeah. Yeah.
This,
Okay, thank you. All right, who's here on Joe Edward Serta?
I am ready.
Let's make quickly vote.
Yes.
I know we're on time crunch here, but having another court saying I have 5 minutes to get there on a magistration on a client that's gonna be arrested.
Okay, we'll take this up now.
Okay.
Yes. All right, court is calling 2023 CR 9473, State of Texas versus Joe Edward Serta. Can I have parties announced for the record for the state?
Daniel Spark from State of Texas.
Defense?
Brandon Lopez for Mr. Soto.
All right, are you Mr. Serta?
Your Honor.
All right, you entered a plea of no contest. And we're set here for a sentencing. According to the plea bargain agreement, state is opposed to your application for community supervision or deferred adjudication. Have both parties had a chance to review the PSI and the TAP evaluation?
Your Honor, I believe this was just a tap because he was, he turned himself into Atascosa for,
Saturday, on the 29th of December.
That's true. That's what I'm reading here. All right. So state, are you still opposed after reviewing the TAP evaluation?
Yeah, and I think Hank has the.
All right. Do you know if Hank is still opposed?
Your Honor, he hadn't mentioned any sort of change.
All right. So then I'll make my decision.
But I think we're opposed. My understanding is that he just has quite a few DW licenses.
All right. All right, probation.
Yes.
On this case, you all are recommending outpatient treatment. Even though you all are recommending outpatient treatment, will you all still let me refer him to inpatient treatment?
Yes.
Okay. And do you know whether or not Felony Veterans Treatment Court reviewed his case here in Bexar County?
I'm not sure, Judge, I have to check.
They have not as of yet, is my understanding.
Okay.
And I understand that they can do that post sentencing, so we
Yes.
were gonna proceed.
All right. So, Mr. Serta, here's the issue with you. You do have a lot of DWIs. I take into consideration that you are a veteran. You were not good on the ignition interlock either. So one or two things can happen because I don't like putting problems off on other people. It's obvious to me that you have a alcohol problem, which is a drug. And they're asking for your punishment to be at 6 years. And what will end up happening is you would be out in 6 years, probably out in 3. And you would still be allowed to drink alcohol if you so choose. So I can sentence you to the 6 years, or either I will place you on probation for 10 years. And you're going into inpatient treatment.
Yes, Your Honor. I believe I'm going to in Atascosa County as well for six months.
So they're asking that you go to SATA.
He's already been sentenced to status through Atascosa.
Well, I'm gonna put him in safe P.
My understanding is he'll do both.
Well, somebody should probably talk to Atascosa, because if Atascosa see that he's going to safety, they may want to not have him go to SATA. They may just count safety.
And we can arrange it.
All right.
Yes.
Court is going to sentence you to 6 years in the prison, suspended and probated for 10 years. There's a $500 fine that will be probated. I'm going to ask for a referral to felony drug court and to Veterans Treatment Court. We'll try Veterans Treatment Court first. I'm going to order safe P. 10 days in the Bexar County Jail as a condition. 2 years license suspension. Ignition interlock for the full term. And I'm saying full term now, counsel, but that may change.
Again.
Victim impact panel, live. DWI intervention, DWI education, 90 sober meetings in 90 days, regular reporting by Zoom or in person, regular random UAs, 200 hours of community service restitution, field visits, 1 time per month for 6 months, then at probation's discretion. And he's to remain in custody until transfer to safe P. Probation, is there anything else he needs? Thank you. Proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors.
And Your Honor, the final thing I'd ask is, can we get an order to remove ignition interlock? He's a vehicle that he's obviously not driving, that's on the outside, that has ignition interlock.
Yes, once you present that order to me, and we'll make sure it's a smooth transition where the ignition interlock is off and then immediately back on when he's, I would say 2 weeks before he's released from custody, ignition interlock needs to be back on the vehicle.
I'll put that in order.
All right. Probation, is there anything else?
No, Judge.
Is there anything else you need from the court to be successful?
No, Your Honor.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. The reason why you're receiving this probation, there are a couple of reasons. Main reason is because your minimum sentence that you agreed to is 6 years. If you just go to prison and don't receive treatment for your alcoholism, what's going to end up happening, because alcohol is not illegal, you're going to get out, you're going to think you're fine, you're going to have a slip up, and you may end up killing somebody. And number 2, because you serve your country as a veteran. You understand?
Yes, Your Honor.
So in this court, in order to be successful at probation, you need to make sure you communicate. Communicate with probation. If you feel as though they're not addressing it, you can always come back here. And you need to be honest with felony drug court and honest with Veterans Treatment Court with your addictions. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
Just have a seat, sir.
Who's here on Pete Castillo? Are we ready? Are we ready on Pete Castillo?
No, Your Honor. I'm still waiting on, where I'm told to talk.
All right, who is it?
It's David Martin.
All right. Norma, could you call David Martin? Jose Villarreal. Are you all ready on Mr. Villarreal? All right, thank you. Nicholas Vaquera.
I'm waiting to hear back from the prosecutor on that right now.
All right, which prosecutor?
County Court 7, it's part of the violation report. I just wanted to get some information from them so I can speak to the court on their position.
All right, y'all have 5 minutes.
Thank you.
All right, the first trial is gonna be Idaho. Are both parties ready on Idaho?
Yes, Judge.
Okay. And then if that falls through, the next one is gonna be Angel Montoya.
I believe, Your Honor, counsel is going through with this client right now. I believe we have an agreement on Montoya.
Okay, so that's an agreement.
Yes, Your Honor.
Christopher Esquivel.
Your Honor, that was the one that was reset. That's the two new cases. Your Honor,
Okay. All right, and then Jesse Garcia.
Jesse Garcia, Your Honor. Oh, I'm so sorry.
No.
Ma'am, I insist. As Norma could say better than I, Judge.
Yeah.
For the family case, that was reduced to a misdemeanor.
Okay.
And with the CTD case, it's on the further trial.
All right, so that's been taken care of.
Yes, sir.
All right, and then Renee Rodriguez.
Renee, so many names, Your Honor.
That's Lorraine's case.
Renee Rodriguez with Lorraine, and that case was dismissed, Your Honor.
And then Ralph Perez, that's
Ralph
with,
Pettis was a
reset.
reset. Yes, Your Honor.
all right. So we're gonna take up Jesse Idaho, but we'll get the agreement done on Angel Montoya. And then for the officers who are here for this, I'll review that.
And then, Your Honor.
Yes.
May I approach?
Sure.
It's short recess.
Let me.
Recess.
Right now. The coordinator is looking into it right now. When this whole thing, yes, I told her. Thanks. Okay.
Sean, just give me just a few minutes.
Okay.
Just give me just a few minutes.
Okay. These have not been e-filed, they're just not finding.
You called me around?
All right.
I will swear them in if they're taking notes. Okay, so I'll just file this. Or it's a full motion in order, or?
No, it's just.
Are we going to the? I didn't think.
That's years of experience. It's great.
All right, can I see the officers?
This is for.
Villarreal, come down. Where are we on discovery?
think we have received most of it, if not all of it.
All right, has an offer been tendered?
Yes, Your Honor.
All right, how old are you?
36, ma'am.
All right, Ms. Ferguson, on these cases, Villarreal? All right, if I can have a 3-week reset for plea deadline date. You can put it the first week in March.
I can do March 7th, Judge.
All right, March 7th is your plea deadline date. At that time, you need to let the court know whether or not you're accepting the state's offer. The court will not consider any plea bargain agreements after that date without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes, ma'am.
All right, do you have any questions?
No, ma'am.
All right, Deputy Laura,
Mr. Honor.
you may take him back.
Yes.
Thank you, Judge.
Thank you. And if you'll just put it here, I'll take care of it.
Address.
Okay. Just remain there. I'm going to sign these very quickly. Could I see the parties on Paul Bell? Is that on the docket today?
No, Your Honor, that's the one that I have approached.
Just give me a moment.
Is it for Martin Larson? Nothing else.
And guys, we're bringing the jury in at 2:30. How much time are you all asking for jury selection?
30 minutes.
All right.
So he doesn't need to be here right now for you guys to announce it or anything. I can end it.
I'm up next. And out. Okay.
Okay, thanks.
And because your attorney contacts him.
Yes.
You should be set for court next week. They contact him and he'll give you those dates, okay? Yeah. Angel Montoya.
You're welcome. All right, you too.
I can wait, right?
You're welcome. All right, who are the parties on Angel Montoya? Court is calling 2022 CR 0054, State of Texas versus Angel Montoya. Can I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Ed Piper from Ms. Montoya.
Are you Angel Montoya?
Yes, ma'am.
Counsel, you received all the discovery. Did you review that with your client?
I did, yes.
Court will find that the state is in compliance with discovery. Ms. Montoya, did you sign and review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Showing you true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
did.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Montoya, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with injury to a child, bodily injury intentionally or knowingly? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison? Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Montoya, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is recommending deferred adjudication. There's an affirmative finding of family violence, no contact with Ariana Garza. Did you understand with the affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as the primary custodial parent?
Yes, ma'am.
Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No.
Next, I'm showing you outside the agreement. The state is recommending that your community supervision be for a term of 4 years. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. State offer states one and attachments.
We did review them, no, Judge.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding you guilty as you've applied for deferred adjudication. Are you proceeding with sentencing? Anything you might want to say on behalf of your client?
Several things. She's 33 years old. This case happened about 3.5 years ago. Since that time, everything's been perfect. It's happened to be the girlfriend of her son, who she thought was leading him down the wrong path. Certainly not handled correctly, but the boy does not date or see the girlfriend anymore. Mom has not seen this girl since that time. She does have full-time employment as a night auditor at a local hotel. She's gainfully employed. She does other side work with other groups that she can tell you about if you'd like to hear, because I'm not familiar with the groups that she works with.
So how old was your son's girlfriend?
At the time, my son was 15, so I was swimming around 14, 15.
All right, so why are you beating up on a 14 or 15-year-old?
I'm not the one who did it.
I'm sorry, what?
I didn't. I've never seen this. Like, I've seen the girl in person, but I've never.
Now, according to the police report, what you just pled to, she was walking with your son in a park and you came up behind her, pulled her by her hair, dragged her by the hair and punched her. So I'm trying to figure out, why are you hitting on a 14-year-old? I'm sorry, what?
I mean,
There's a video according to the police report.
it's. Hmm. I know there's a video. I know it's a blurry video. I know it looks like me.
So are you saying that this is just all made up?
Oh gosh.
No, if you want a jury trial, we will give you a jury trial.
I mean, I don't want it to go bad and make it, and I go to prison for something I didn't do.
Well, here's the thing. If you're saying you didn't do this and you want a jury trial, then guess what? In the 187th, I will put cases to trial and we will give you your jury trial. But what I'm reading in the police report, there is a video. And yeah, it's saying that you pulled her hair, you beat her up.
Yeah, I'm aware of what she said I did.
So your only question is, do you want a jury trial or not?
I don't want to do a job.
All right. So then we're back to the point. Why are you pulling on a child's hair?
So no, I was angry. I was really, really upset. My son wasn't going down any wrong path until he met this girl. They were doing drugs. He was running away. He was stealing cars. I was just trying to be a good parent.
Well, I mean, how is it a good parent to beat up somebody who's dating your son? Why do you think that she's in charge of your son's actions? Did she put a gun to his head and say, do these drugs with me?
She told my son she was pregnant.
All right. then people need to start supervising their children better.
That's true.
I'm going to sentence you to 6 years deferred adjudication. There's an affirmative finding of family violence, no contact with Ariana. That's Ariana Garza. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular UAs. No unsupervised contact with minors. 200 hours of community service restitution. I'm going to order parenting classes. Once she's completed parenting classes, that will be deemed satisfied. There's to be field visits, 1 time per month for 3 months. And there's to be 30 days in the Bear County Jail as a condition of probation. Is there anything else she needs? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Good luck.
Judge, as far as the 30 days, since that was not part of what we had anticipated, can she either have time to turn herself in Friday or do weekends?
No, they don't do weekends anymore at the jail.
So I gotta go to jail for 30 days.
Yes. All right. Everyone, your cases are going to be recalled. We're going to start this jury trial and line up the jurors. And then I'm working on your thing. And then on bail, if I could see you all both in the hallway very quickly. And Norma, the other cases, if you can recall them on Thursday.
Can we do Friday?
Come on in. Come on, everyone. First row has a number. Number 8, who's number 8?
No, you
Second
maybe
row
sit,
on
but
top?
don't sit
Oh.
on the numbers, just lift the numbers, yes.
15 is 15. On the bench.
You're gonna need those numbers.
22. Next row. 22 is next row.
Maria?
30. Who's number 30? On the second row. It is 37. Who's 37? Next row.
Yes.
44.
Oh.
44.
I don't think so.
44. Wait.
I will tell you, I go to different countries to see their jury selection, how they do things. In France, it's all computerized. Everything is video from the time you come into the court. So, but we're not there.
You'll be your numbers. This is 56, you're in that corner.
But surely people love downtown traffic.
One.
Be seated. All right, everyone, good afternoon. Thank you, juror number 1. Everybody else is moving slow today, so I'm going to pretend like I'm just saying it. Good afternoon, everyone. Awesome. So you are in the 187 District Court. It is on the 4th floor, and I am Judge Boyd. So where are you?
4th floor. 87.
All right, you guys are trailing off like you're singing Old Lang Syne, where everybody knows the first verse, then they just start trailing off. So I always tell people that you're in the 187th District Court, 4th floor with Judge Boyd. The reason why I tell people that is because whenever we take a break, we cannot start again until everybody is in the room. And when we take a break, everybody has to leave the room. And sometimes people will get lost. So if we take a break and you get lost, really all you need to know is 187th, because in all of Texas, there's only 187 District Court in all of Texas. And if you don't remember that, if you just remember Judge Boyd, I'm the only Judge Boyd in the entire courthouse. All right. So nobody should be getting lost. So I'm going to let the state introduce themselves to you, state.
Hi guys, I'm Allie Jackson.
Hey everyone, I'm Zach Dunn.
And defense.
Hi, I'm John Reitler.
I'm Christine Brown.
And your client.
Hey everyone, my name is Jesse Nopel.
Okay. All right. So I'm going to come back and ask you all if you recognize any of those parties in just a little bit. Sometimes you need to see people walk around and then you'll say, I do recognize that person. In the center is our court reporter. Maria, could you raise your hand? Right. I always said that if I was ever in a position to make somebody's job easy or easier, I would. So we're going to make her job as easy as possible. And this is how we're going to do it. She takes down everything that everybody says. If you whisper, it's going to be difficult for her to hear. If you're on the back row, you need to talk at the same level that I'm talking out at to make sure that she hears you. Because if she can't hear you, then it's like it never happened. Does everyone understand?
Yes.
The other way to make her job easy is we only talk one person at a time. And if there's something you want to say, you need to raise your card. So could everyone raise your cards for me, please? And keep them held up until I tell you to lower them. Everyone in the box, lower your card, please. Everyone on this front row, lower your card. Everybody else who has your card up, I want you to listen to me, retain this, because every single jury we've had in this court, and we're in trial every week, have failed this test, and I don't want you guys to fail it. So if your card is still raised, whenever you answer a question or you speak, if you can, we're going to need you to stand. So can everybody do that?
Yes.
Is anybody going to forget that?
No.
All right, please don't disappoint me. All right, you can lower your card. All right, so you're here for jury selection. And I always know that people never want to come down for jury duty, or sometimes people will say, you know what, I really would like to be here on a civil case. Let me handle a case involving money. Usually on the criminal side, things are slightly different, and people never want to come and try cases on the criminal side because it's the criminal side. But we cannot have a jury trial if we do not have jurors, right? So I understand that some cases people have, and people always give an example where they say, well, if your car was burglarized this morning and you come to work, then maybe you should not be able to sit on a burglary case. But really the question is whether or not you can be fair. My mom always says, if I were attorney Stephanie, I would ask 2 questions. And I'm like, Mom, what's your 2 questions? She's like, 1, can you be fair? Can you just base your decision on the evidence you hear in the courtroom? That's what fairness really is about, is no matter what has happened in your past, if your car has been burglarized before, if your home has been broken in before, if you've been mugged before, that's not really the question. The question is whether or not you can listen to the evidence in this specific case and make a decision on the evidence that you hear. Does everyone understand?
Yes.
So my mom said, I would ask that question. And she's like, the other question I would ask would be, do you have common sense? And she's like, everybody has common sense. She said, that would be my 2 questions for jury selection. I'm like, Mom, I will let the attorneys know that they should only ask 2 questions instead of 30 minutes each. So in this case, everybody's going to talk to you in hypotheticals. Neither the state or the defense is allowed to tell you what they think the facts are in this case. So when they speak to you, it's all hypotheticals. So don't be in your mind saying, so that's what this case is about. Those are the facts of the case. They're not allowed to talk to you about what the facts of the case are. You will only get to hear what the case is about if you're selected for the jury and witnesses come and testify. Does everyone understand? Now, the charge in this case, there are 2 counts. The first count is aggravated sexual assault of a child, and the second count is indecency with a child by contact. And I'm going to come back and talk to you about that in more detail in a moment. So the way somebody comes to trial in a felony court, they have to be indicted. How many people here, I'm going to have you practice raising your cards. How many people here have ever had a traffic ticket? All right, so we got a lot of bad drivers. Keep them keep those numbers hold up. So that way I'll know if I see you on the road to just avoid y'all. All right. You can lower your card. So I've had a traffic ticket before in my life. I want to say I was about 18, 19, maybe 20. And I'm only 21 now, so that's still fresh in my mind. All right. So anyway, back then they would have a paper pad and they would write your ticket on it and hand it to you. Now I think they do some sort of electronic thing or something. But the thing about traffic tickets is this. Let's say an officer pulls you over and they say you ran a red light and they write you a ticket for it. When you're there writing you that ticket and you accept it, you're not saying, oh yeah, you're right, I ran a red light. You're just accepting that ticket so you'll know what they're accusing you of and you'll know where you're supposed to appear. It is not an evidence of guilt or anything of that nature. So in criminal cases on the felony side, the fact that somebody is indicted, that's not evidence of guilt. It cannot be used by you as evidence of anything. It's just a piece of paper where somebody knows this is what you're charged with and this is where you need to come for if you want to go to trial. Does everyone understand?
Yeah.
Is there anyone here who's going to hold it against Mr. Idaho because he's here under indictment?
No.
All right, 39. All right, you may be seated. All right, the next thing I want to talk to you is certain rights that everyone has. One of those rights is the right to remain silent. For the people who've watched Matlock, Perry Mason, The Practice, any of those law shows, hopefully you've heard of the right to remain silent. Has everyone heard of that before?
Yes.
All right. So what does that really mean? That means that nobody has to testify. You know, someone who's accused of a crime does not have to testify. I've been a defense attorney. I've been a prosecutor. Sometimes as a defense attorney, my client maybe was so nervous. I'm like, you know what? You don't need to testify. We have other people who are going to come in. Or either sometimes it's, you don't need to testify. The state didn't prove their case. So there are many reasons why people won't testify. Sometimes they have a bad stutter. Sometimes they're extremely nervous because, believe it or not, they say that public speaking is one of the biggest fears that people have. So everybody has a right not to testify or to remain silent. The Constitution guarantees you that right. Is there anyone who will hold it against Mr. Idaho if he chooses not to testify? All right. And the thing about when somebody decides not to testify, you can't be like Mrs. Kravitz from Bewitched and say, well, I wonder what they would have said. You can't hold it against them. You can't consider it whatsoever. Does everyone understand?
Yes.
Now, the next thing is everyone is innocent until proven guilty. So you know what that means? That means that the state has to prove their case. And sometimes people will look at jury trials and they think that, oh, is a person innocent or not innocent? When really is, did the state prove their case or did they not prove their case? So because someone is presumed to be innocent, oh, who's this gentleman? Okay. All right. People will come into this courtroom and sometimes, you know why they come in? Because they don't see outside the door where it says jury trial in session. Please do not walk in. They may come through that door and they don't see the sign that says jury trial in session, don't come in. Because I'm presiding judge, I may have officers who are coming in for me to look at search warrants or things of that nature. They'll usually come in through that door. It has absolutely nothing to do with this case. So don't even pay attention to that. And sometimes there are students who want to watch jury trials, so they'll come in just to observe. All right. So innocent until proven guilty. That means that the state has the burden of proof. It never shifts to the defense. So the defense doesn't have to prove anything. So if ever you're deliberating on the jury trial and you ask yourself, well, the defense should have done A, B, and C. You know you're in the wrong place because the state has the burden. They have to prove each and every element beyond a reasonable doubt. In law school, our professors used to tell us, you know, if you're a defense attorney, you could sit over there and you could play word games. You could go to sleep because some attorneys have gone to sleep. We've read case law on that, right? you don't have to do anything. Now, I've never seen that happen in my experience where defense attorneys say, hey, you know what, let's just play some crossword puzzles. But our professors told us that to make sure that we realize the defense does not have to prove anything. Does everyone understand? So the burden never shifts to the defense. The burden always is with the state to prove their case beyond a reasonable doubt. Now, I know you would say, okay, what's the definition of proof beyond a reasonable doubt? When I was in law school, there was a definition. You had to know it forwards and backwards. If you did not know it, you basically were a failure. So I graduate from law school, take the bar, pass the bar. I have my first jury trial. I say the definition to the jurors. I put the comma in the right place. I pause for dramatic effect, put the exclamation point, and guess what? After that jury trial, there's no longer a definition for proof beyond a reasonable doubt. So I would start telling people what it wasn't. Next door, you have the historic courthouse with the green rooftop. They try civil cases. So one of their burdens is preponderance of the evidence. Usually that's involving money. And that burden of proof is more likely than not something happened. So if you're ever in a criminal trial and you're deliberating and you're in the back saying, you know, I believe maybe this happened more likely than not, you're at the wrong burden of proof. Does everyone understand? The other burden next door, their highest burden is what's called clear and convincing evidence. That burden is what is used to terminate your parental rights and say you're a bad parent. We can't trust you with your child anymore. So legally, we are no longer going to let you be this child's parent. I think everybody would agree that should be a very high burden. Guess what? There's a burden that's higher than that, and that's proof beyond a reasonable doubt. Does everyone understand? Yes. Now, there are two phases of a jury trial. First phase is whether somebody is guilty or not guilty, whether the state proved their case or did not prove their case. That's the first phase. If you find that the state didn't prove their case, then it's not guilty. If you find that the state proved its case, then it would be guilty. And you would go to the second phase. And the second phase is called the punishment phase. Every person who is charged with a criminal offense before jury selection must make an election or selection for if they were found guilty, who would they like to decide their punishment? You cannot hold it against someone if they chose to go to the jury for punishment or the court for punishment. And they're making that selection is not saying they are guilty. It's just that the law requires them to make a selection. So in this case, Mr. Hinault has decided that if he were found guilty, he would go to the jury for punishment. Is there anyone here for religious reasons who cannot sit in judgment or punishment of others? Okay. All right. So let's talk about the ranges of punishment. And when I talk to you about the ranges of punishment, they are wide. For example, for aggravated sexual assault of a child, the range of punishment for that offense, if somebody were found guilty, is 5 to 99 years or life in prison. So what does that mean? You could give somebody 5 years, 6 years, 7 years, count all the way up to 99 years or life. For indecency with a child by contact, that's a second-degree felony. The range of punishment for that is anywhere from 2 to 20 years. So you can give somebody 2 years all the way up to 20 years. So I think everybody agrees that's an extremely wide range of punishment. Now, indecency with a child by contact, someone may be able to receive probation for that as well. So if you are selected for this jury, you must be able to consider those ranges of punishment. Notice I didn't say give someone a particular punishment. Does everyone understand? Yes. All right. So this is what that means. Nobody knows the facts of this case. And sometimes when you ask people, can they consider the full range of punishment? The first thing they say, well, Judge, I need to know some more information. before I can say I can consider it. So you just need to be able to think in your head different scenarios where maybe you would consider giving somebody 5 years, maybe you consider giving somebody life, maybe you consider giving somebody probation. These are all things that you can think of. And let me just give you a hypothetical. Sometimes you have cases involving, let's say, someone who is 21, right? And maybe the complainant, not maybe, the complainant is underage. And then I watch news shows where somebody's underage and then all of a sudden they come back on a news show and they say, we've been married for 30 years or whatever. So there are different scenarios. Now, maybe you may see somebody who's underage and the person who's accused of having contact with them are in their 30s or 40s. And you're like, so there are different reasons maybe why you would send somebody to 5 years or life, or maybe you send somebody to 2 years or 20 years, or sending somebody to probation. Does everyone understand? Now, you don't know the facts of this case, as I said before. Is there anyone, if you were to find somebody guilty, is there anyone here who cannot think about those ranges of punishment and apply whatever facts you have to make a decision on what the range of punishment should be? Is there anyone who feels they cannot do that? Okay. If you'll keep your cards held up until I call out your number. 1, and you can lower your card once I call your number. 4, 8, 10, 22, 32, 36, 65, 67, 72, and 74. Thank you. All right, now I want to talk to you about the one witness rule. That's what some people call it. I'm going to give you a hypothetical. Do not add anything to my hypothetical. All right? So let's say someone is in a parking garage. They're going to their car. They're just opening the door. And some other person comes in that parking garage and robs them. They take all of their items and they take off running. And the person in the parking garage is able to identify them. So they call the police, say, hey, I just got robbed. Let me give the description of the person who did it. Is there anyone here who thinks that the person who got robbed should have not called the police? Is there anyone here who thinks that the police officer should not have taken that report? Is there anyone here who thinks that that person should not be able to come to court and say, that's the person who robbed me in the parking garage? Is there anyone who feels that way? So let me explain to you about a one witness rule. Let's say that same scenario. You have someone in the parking garage and somebody comes in and robs them. The lighting is great. There's no issue with lighting. They don't wear glasses like we do. They have perfect vision. In your mind, it could be Mother Teresa. It could be anybody, right? It's somebody who you find to be credible. And what does that mean? That means that you listen to them testify and you believe they're telling the truth. And when that person testifies, they prove for the state through their testimony, this is the day it happened. I was in Bexar County in the parking garage. John Doe is the person who did it. I recognize John Doe. That's John Doe. These are the items they took. So you believe that person, no issue. Is there anyone who would not be able to find somebody guilty in that fact scenario I've just given you? All right. 49, 50. That is essentially the one witness rule. Somebody comes in to testify and you believe them. Now, a lot of times people get caught up in that one witness rule because they start saying things, well, did the officer do A, B, and C? Did this happen or did that happen? You're bringing other things into the fact scenario that I've given you. The fact scenario that I've given you, what it means is there's no question in your mind that that person is credible and that they're telling the truth. Does everyone understand? Now, the next thing I want to talk to you about is the English language. I love languages. When I went to school, there are people in my class who spoke no less than 6 languages. And usually it was the people who were from the Middle East. They spoke six languages. One of my friends speaks Navajo. She tried to teach me. It was very difficult. I'm originally from Louisiana. So guess what language I took? Because I just knew I was going to be retired in France.
French.
So my friend, she ends up taking Spanish and she was like, Stephanie, take Spanish with me. I was like, girl, I am going to France. I need to know how to speak this language. And here I am. So is there anyone here? English is not your first language. If English is not your first language, please raise your card. All right, number 5, 49, and 70. Number 5, what's your first language?
Spanish.
All right. Have you been able to understand everything?
Yes.
All right. And how do you say hurry up in Spanish?
What a thing.
There's another way to say it too. What's the other way?
There's 100 different ways. I don't
See?
say them though.
I always
Too many bad ways to say it.
Yeah, I always tell people that. That's what I've been able to do.
Dale.
Yes. Every student I was with, they were able to teach me how to say hurry up in their language. So that's the one thing I do know. 49.
Spanish.
You guys are failing me.
Spanish.
All right. Have you been able to understand everything?
Yes.
All right. Thank you. Number 70.
Spanish.
Have you been able to understand everything?
Yes.
All right. Thank you. Now, the next thing I want to talk to you all about is time constraints, travel arrangements. I'm anticipating that this case will be completed by Friday at the latest Monday. Is there anyone who has some type of travel arrangements? You have tickets that are non-refundable. You can't transfer them to me. Is there anything of that nature? All right. So
Yes.
hold your card up. And once I pass your group, do not put your card up. So anybody in this box? Yes.
Just trip arrangements or like, could it be like a job?
Any time constraints. You can let me know what your time constraint is. Number 8, 10, 19, 30. And once I call your number, you can put your card down. 32, 44, 46, 50, 66, and 70. Number 8, what's your time constraint?
New job starting Monday.
Okay. All right, thank you. Number 10.
Work related, having so much work, because practice I was doing this recently, I think it should be on.
All right, thank you. Number 19.
They have reservations.
Where is 19? You-
Sorry,
okay.
reservations out of town on Monday.
Oh, where are you headed?
Sunday and Monday.
All right, what are you doing in Fredericksburg?
Wine country.
All right. And that is Monday?
Sunday to Monday.
Sunday through Monday. All right, number 30.
I will be traveling to Miami on Saturday.
Miami on Saturday. What you doing in Miami?
Family reunion cruise.
Oh, all right, thank you. Number 32.
32.
Yes. Yes. What is your time constraint?
I'm chronic condition, so I have appointment all this month.
All right, thank you. Number 44. All right, I'm sorry, you're gonna have to speak up a little bit.
I'm going to Disney on Thursday, so I won't be back until Sunday, and then I start a new job.
All right, so you're going to Disneyland or Disney World?
Disney.
All right, thank you.
I have a question.
Yes,
Is it just during the weekdays?
I'm sorry, you need to stand up.
Is it just during the weekdays or the weekend?
We're not working on weekends.
Awesome. All right.
All right, thank you. Number 46.
I have out of state travel next week for a campus visit for my college campuses.
All right, where are you going? Oregon? Why not LSU? But okay.
She actually already checked there. So,
Okay.
so that's on our list as well.
All right, and what date?
If the trial were to be ended by Friday, I'd be okay. But if it starts next week, we'll be out of town for the majority of next week,
All right, when are you leaving?
Tuesday.
All right, are you all flying or driving? Okay, all right, thank you. Number 50,
Traveling to Houston on Friday,
what are you doing in Houston?
going to the Eagles concert.
Ah, look at everybody all jealous. Well, you know, maybe you should have went to California. You get the reference? All right. Number 66,
Cousin's wedding in Dallas.
do you have a role in the wedding?
I'm best man, I guess.
Well, I mean, are you having to wear a tux? Are you standing up for anybody?
Oh yeah, I'm right next to
Right next to who?
my cousin getting married. I gotta make a whole speech and everything stuff.
Oh, you have to make a speech. So when is this?
I'm leaving Thursday, but it's Saturday.
All right, thank you. 67,
I have school Monday and Wednesday,
and where are you in school at?
Northwest Vista.
Is this in person?
Yes.
What are your hours?
My first class starts at 9 and my last one ends like at 6:15.
All right, thank you. Number 70,
Going camping,
oh, where are you going camping?
Corpus Christi,
All right, and what date?
leaving Sunday and Monday, returning Monday afternoon.
Do you really want to go camping? The weather may not be nice.
Oh,
She's like, I don't know. All right, thank you. All right, so before I give us a short break, I'm going to tell you all two stories, and both of these stories are true. I realize that jury duty, it's an inconvenience. I tell people it's an inconvenience. It's not a sacrifice by any means. And the reason why I tell people that is because, one, the government could probably change the law and say you have to come up every month. And I know there are some people here, this is probably your first time being called in 3 years, maybe. So the government only asks you to come to do jury duty, right? And they ask you to pay your taxes. That's all the government asks of you. There's not a draft. They're not asking you to go to a draft. I understand that for some people who don't come downtown on a regular basis, you come down and you're hit with a bunch of one-ways. And you're driving and you're like, if I could just turn right. The building is right there. But no, you have to do a complete circle. And if somebody's being mean and not letting you over, you have to do another complete circle. Then you have to pay for parking. And I'm sure you're probably saying to yourself, I'm coming down to do you a service during jury duty and I got to pay for parking. I understand all of this, but it's an inconvenience. It's not a sacrifice. And the reason why I can say that is because I'm going to tell you about a sacrifice. So my uncle grew up in a small town called Grand Cane, Louisiana. Firstborn son and super intelligent. All the teachers knew him. That was back in the day where every single teacher knew every single student. And the teacher's class you were not in, they knew you still. So the teacher would just advance him to the next grade because it's like, there's nothing else for me to teach you in this course. We're just going to advance you. So when his brother and sisters came up behind him, the teachers told them, you better show us what he showed us because he's super intelligent. Of course, they were like, curses. You know, we can't slack a little bit. So he graduates from high school and the Vietnam War breaks out. They are drafting people in Grand Cane. He goes to my grandmother, and that's her firstborn child. And he says, there's no way I can advance. I should probably just sign up for the military and I need you to sign for me. That's a sacrifice because when you think about it, that was her firstborn. And when you think about it, and I know some people are young, they were living in a time where you had 3 stations. One was NBC. NBC, the weather would have to be perfect for it to work. You'd have to have your rabbit ears if you had them turned a certain way. And then half the time, the picture would still have white lines you could barely see. And that was a time when, guess what? the television wasn't 24/7 the way you have now. The station's end, and you know how you know they're coming to an end because they start playing the national anthem. And depending when they got more advanced, at least you just see the flag waving on the screen, but there would be nothing else. My grandmother's phone, when she picked it up to call, the operator would answer. There wasn't this dialing the number. You would call and you would say your number. That's why they have that song, Beechwood 7489, because there were 4 numbers and the operator would connect you. The way you get on a computer today and emailing people and texting people, they didn't have cell phones back then. They didn't have the computer back then. So she had to sign for my uncle to go off to Vietnam. And guess what? Half the people didn't know where Vietnam was. She didn't know what was going to happen to her son, but she sent him. And that was in the day where they say, here's your son's ID number. You just put it on the letter and just put Vietnam. That's it. And then you wait for that letter to come back, hoping your son is okay, hoping they're making it back. You send letter after letter, but nothing comes back. And then, you know, when you're in the military, your lieutenant or sergeant, whoever it is, say, everybody write a letter to your parent. And then you're waiting for 6 months to get a letter back. So that was a sacrifice. So when you think about what your country is asking of you, your country is not asking you to serve in the military, to go fight a war. There's no longer a draft. Draft is not coming back unless there's some bill to make it come back. So my grandmother had to make a sacrifice, and my uncle made a sacrifice because he signed up to go in the military when he was underage. So these are sacrifices. So what we're doing now, it's an inconvenience to you, although I do appreciate the fact that it is an inconvenience. The second story I'm going to tell you is about my friend. We went to law school together, and she chose to do civil work. She said, Stephanie, I'm being up for jury duty. Let's do lunch. I'm like, this is great. Let's do lunch together. We do lunch. I ask her how jury duty is going. She tells me it's going fabulous. Now that I'm a judge, I don't know how it could have been fabulous because she wasn't with us, but she says it's going fabulous. And I say, why? She's like, it's like we were in law school. I'm on the back row. I'm keeping my head down, not saying anything. And I start laughing and she says, what's so funny? I said, we're going to be able to have lunch all week. So other than raising a sign saying, please pick me, the quickest way to be selected is if you say nothing. And I tell people that story because I want you to talk to both the state and the defense because they have a small window to speak to you to decide whether or not you would be a good person for this jury. And remember what I said, when they ask you if you can be fair, what it means is whatever may have happened to you in your life, if you're selected for this jury, will you be able to base your decision on whether someone is guilty or not guilty based upon the facts in the courtroom? Does everyone understand? All right. Does anyone need a break before I turn it over to the state? All right. Maria, do you need a break? All right. State.
All right. Good afternoon, guys. There we go. We're still awake. It's fine. I know you guys have had a long day. Thank you for sticking it out. So before we get down into not even really details, but to talk more about the law, I want to do a little housekeeping first. A, just to remind you to hold up your card whenever you answer. But then B, if you make it onto the jury, you're not going to be able to have your cell phone out in the courtroom, but you may see me and Zach or the defense on our cell phones. Please don't think we're being rude. This isn't like on TV where it's just like, oh, this is the only thing we're doing. It's no, sometimes we're having to wrangle witnesses, arrange other things. So if you see us, please don't side-eye us. Just want to put that out there. So we're here today for jury selection, but really it's more about deselection. We don't get to say, oh, you know what, I really like number 68, this is the person for me. It's more about you guys answering our questions as we talk to you about the law and learn more about you. And sometimes there's reasons for you not to be fair and impartial, and we're gonna kind of get rid of you. And that's why Judge was saying that if you don't say anything and we don't know anything about you, we have no reason to strike you. So we need to find 12 fair and impartial people who are right for this case, who can be fair to both us and both defense. So we're not going to talk about the facts, but we are going to talk about what Zach and I have to prove. Like the judge said, one count is for aggravated assault, aggravated sexual assault of a child. We have to prove that on or about a certain date, the defendant did intentionally and knowingly cause the sexual organ of Christina Hinojo, a child younger than 14, to contact his sexual organ. Now, when you say younger than 14, I still can't tell you an age, but to give you an idea of what we're looking at, there's another even higher charge called a super ag. And that's if the child is below the age of 6. So at this point, you can think that we're looking between 7 and 13 is the age range we're talking about here. The next count is indecency with child by contact. We have to prove that on or about a certain date, the defendant did intentionally and knowingly engage in sexual contact with Christina Hinojo, a child under 17, by touching her breast with the intent to arouse or gratify the sexual desires of any person. That's a mouthful. You can also see that I talk about this stuff every day. Been in this unit for 5 years. I promise everybody's going to help walk those of you who make it onto the jury panel. We'll walk you through this. You're going to understand the law. You don't have to memorize anything right now. Just to get you familiar with what we're talking about. Now, one of the things you may have noticed in there is on or about. We don't have to prove a certain date. Is there anybody who can think of a reason why we wouldn't have to prove a certain date for something like this, for a sexual case with a kid? Number 4.
There's no statute of limitations.
Okay, no statute of limitations possibly. Number 8.
Is it gonna happen before or after that date?
Yes. Who here thinks kids number 5?
Could have been habitual.
Could have been habitual. Could have been more than once. Who here, raise your hand or your card, rather, if you have kids. Okay, keep those cards raised if you think kids are really good with dates. Yeah, none of you. Can't expect a child to remember sometimes their birthday, let alone jot down a date when something like this happened. So under the law, we don't have to prove a certain date. We just have to prove that it happened before we indicted the case. That makes sense. Now, is there anyone here, and it's totally fair, there's no wrong answers here, we just gotta know, who says, Allie, I get that, that's great, but I cannot convict someone unless you prove a date to me. Please raise your hand. Number 32. Alrighty. So sexual contact, that's what it talks about in the indecency with child. This is pretty straightforward, but just to kind of put the law out there for you. This is any touching by a person, including over the clothing, of the anus, breast, or any part of the genitals of the child. So it can be over the clothing, it can be under the clothing. That's the indecency. Now, one of the things you may have noticed also is that there's nothing in there about consent. And this is because kids can't consent under the law. If you are under 17, you cannot consent, period. Doesn't matter if you flirted, doesn't matter if you hit on someone, it does not matter. Now, again, is there anyone who says, that's great, I understand that, but unless you can show me some kind of force, I'm not going to be able to find a person guilty of this. Raise your card. So, answers? Yes, number 2.
Was person that's accused a child as well defined?
No, I can say that that would be handled in a different place. Yes. So just knowing that the person would, number 8, yes.
That was a child.
So I can't answer in detail, but I can say that knowledge of age is not a defense. I can't answer as to the facts of this case. Now, the judge said beyond a reasonable doubt, there's no definition. Lawyers like to define everything except for like the highest standard of evidence in the land. But I can tell you what it's not. It's not 100%. It's not beyond all doubt. And just because something's possible does not mean it's reasonable. We ask you really at the end of the day to use your common sense. So let's say that before you guys came in here, there were reports that we were expecting rain. There's clouds in the sky. The wind was starting to pick up. But you did manage to escape after only 30 minutes instead of staying here all day. You walk back outside and it's wet. There's puddles on the ground. The cars are wet. People are holding umbrellas. Maybe people even have water kind of on their shoulders and their heads. What happened?
It rained.
It rained. You didn't see that. You didn't witness it, but you know it rained. Now, is it possible that somebody who hates the courthouse was like, you know what? I'm going to take a fire hose and spray everybody down and all of their cars down? Yes, but that's not a reasonable assumption. Everybody get that? Yeah. Okay. So when we talk to you about reasonable doubt, it's fine to have doubt. We are asking for you to look at the things that we have to prove, those two checklists. And you say that I believe beyond reasonable doubt. I can have questions. There might be some puzzle pieces missing, but at the end of the day, I know beyond a reasonable doubt that what is this? A gun. Ask yourself 3 questions when you're considering the evidence. Do I have a doubt? Is it a reasonable doubt? And did it go to one of the elements that Zach and Allie had to prove? Now, again, is there anyone here who says, I understand that, and I know that that's the law. However, I just cannot do it. Now, I will point out, what is the only way to know 100% that something happened? Number 4, if you see it. If you were an eyewitness, you'd be on the stand. You're not going to be in the jury box. But hearing all of that and knowing that, is there anyone who says, I cannot convict unless you prove beyond all doubt? I can't have a single doubt left. Please raise your card. Number 2, number 8, 32, and you can lower your card after I say it. 44.
I just have a question.
Yes, 47.
I'm not sure I completely understand what you mean by reasonable.
It's, we can't really define it. It's more you have to use your common sense. Like you yourself have to determine, is this enough for me? Basically. And are you comfortable? Can you do that? Number 35. Okay. Number 59, 62, 65, 66, and 72. And number 10. All right. Now, this one we're gonna be a big participation, guys. So listen to me when I read it, kind of ponder it for a second before I'll have you guys answer. Which do you think is more common? Number 1, a child makes up a completely false allegation of abuse. Or number 2, a child denies being abused when they actually were. Raise your hand if you're a number 1. I think it's more common for a kid to completely lie and make something up. Raise your cards. All right. Raise your cards if you're a number 2. All right. So 1, 2, 3, 4, and you can put yours down as I say it. 5, 6, 7, 8, 9, 10, 11, 12, 13, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 48, 49, 51, 52, 53, 54, 55, 56, 57, 58, 59, 60, 61, 62, 63, 64, 65, 66, 67, 68, 69, 70, 71, 72, 73, and 74, and 75. Alrighty, now, I'm not gonna make you answer questions about any of this, so don't freak out. But I just need you to raise your hand if you or someone close to you, whether it be friend or family, was a victim of sexual abuse. And we're gonna do this in more detail later, so we'll mark these down. So raise or keep your hands up, but lower your card if that person told right away. If they told right away, immediately after it happened. Okay. Lower your card if it took a few weeks to tell someone. Lower your card if it took a few months. Lower your card if it took at least a year. Okay. Lower your card if it took 5 years. Okay, so we still have, you guys can all put them down. It takes time. Why don't children tell right away? So we can give you an idea. Number 4,
They're just afraid.
they're afraid, and what are they afraid of?
They're afraid of repercussions from, a lot of times if it's family members, they're afraid of the repercussions it'll cause within their family.
Okay, number 7,
They feel like they did something wrong.
they feel like they did something wrong. Number 51, can you stand please? They feel like no one might believe them. 16,
They don't understand what happened.
they don't
What's wrong?
understand what happened. 39,
Threat or imminent harm.
they could be threatened. 48,
They don't know what was going on.
they don't know what was going on when it happened. Number 3,
They didn't say nothing, they believe it didn't happen.
okay, yeah, if you keep quiet, it didn't happen, you can forget it. So, please raise your hand. This is another one. We're either gonna do a 1, where I believe a child would tell when and if they're ready. Or number 2, I believe a child would tell right away. Raise your hand if you're number 2. I believe a child would tell right away. All right, everybody raise your hand if you're number 1. Not gonna read out the numbers again, but lower your hands. Raise your card if you abstained from voting. 47, 73, 35, 30, and 39. Okay. So let's talk briefly about evidence. This is not CSI. This is not Law and Order. What you're going to discover is that all of the evidence comes from up here. Testimony is evidence, and people who come in and testify, they're the ones who bring in whatever type of evidence it is. So they're going to talk about what they saw, what they heard. But let's talk about what kind of evidence to expect in a case like this. Keeping in mind, we've already talked about delayed outcry. If a child took a while to say something, who here thinks there's still going to be physical evidence to find? Raise your card. Okay. What types of things can affect that? Who has an idea? Number 4?
Weather.
Weather, okay. Number 51? 68? Time. Time is the enemy of all evidence, especially in a situation where it's been just a while since the kid was abused. Is there anyone here who says, I understand that, but if I'm going to convict somebody for this type of offense, I need DNA evidence? Is there anyone here who feels that? Number 32, 31, 5, 8, 33, 43, 62, and 66.
I have a question.
Yes.
The slide says or scientific evidence, so I'm wondering what's the difference?
I just
Asking
kind of
for
DNA.
DNA or-
DNA. Yeah, if there's anybody out there who would require any sort of scientific or medical evidence, you can also raise your card if you didn't before. Now, who here, again, raise your card, who here has, and specifically teenagers, or has had a teenager that you've raised? Okay. Number 12. Do you have a current teenager or somebody who's already past that stage? Okay. Can you tell when your teenager's lying to you? Not always. Okay. What are some signs you look for?
Deviating pattern of their normal behavior.
Okay. Number 3, what would you look for to see if your kid's lying?
Gesture.
Gestures. Okay. 15.
Shifty eyes and.
Shifty eyes. Yeah. Who here thinks that they kind of evaluate whether their kid or anyone else is lying just on a day-to-day basis in your daily interactions? Raise your card.
Can you repeat that?
Like in your day-to-day interactions, whether you're talking to your child, your spouse, who here thinks that you kind of always have to kind of be evaluating whether or not someone's telling you the truth? Yeah, we do it every day. You know, we look at stuff like demeanor, body language, you know, what they're saying. So we all do it on a daily basis. Is there anyone here who's like, I cannot sit and listen to people that I don't know and judge their credibility?
I have a question.
Yes.
Just because it depends on the age of the person that is the witness. Wouldn't expect a child to necessarily be articulate, and I would not be able to judge the truthfulness if they were really hurt.
Okay. If they're really nervous. Are kids going to testify the same way as adults?
No.
No. So it can have a big difference. Is there anyone, I know I just asked it, but let me ask it again. Is there anyone who says I cannot sit and judge someone's credibility from testimony? Raise your card. Number 5, 8, 21, 24, 28, 32, 47, 49, 51, 55, 60, 65, 72, and 74. Now, knowing that we're talking about aggravated sexual assault of a child and indecency with a child, where do you guys think that these crimes usually occur?
At home.
At home, behind closed doors. Now, that's why Judge talked to you about the one witness rule, because the only person who can decide where a child's going to be abused is the person doing the abuse. And it's not going to be in front of friends and family. It's not going to necessarily be in the middle of like Six Flags. It happens behind closed doors. And that's why the one witness rule is so important. Now, we already talked a little about this, about how kids aren't going to all testify the same. But now I'm going to ask somebody a very uncomfortable question. Jury number 13. Can you please tell me about the last time you had sex? I'm going to stop you. How did you feel when I asked you that?
A little awkward.
Awkward. Who here else felt awkward when I said that? Who here was kind of afraid you might be nuts? How do you think a child is going to feel coming in and telling her 20 new best friends about what happened to her? Ashamed? Who said that? Number 19? Okay. Who agrees with number 19? Maybe ashamed. Right? A lot of people. Any other thing you might expect a child having to come in? 51? Scared. Scared. 21?
I'm embarrassed.
Embarrassed? Yeah. It can be really difficult. All right. Now, here's another wild question. Raise your hand if you're a fan of sexual abuse. None of you are. Nobody wants to be here. Nobody ever wants to hear these types of cases. And we get that because from when we talked about it earlier, most of you know someone who has experienced this. What we are asking you to do is to put that aside and judge based on this evidence that's presented to you and that alone. But we're going to ask that first question once again. Please raise your card if you and a close friend or family member, which is actually going to be a different one, has ever been arrested for this type of crime, for a sexual offense. Number 3, 4, 5, 10, 22, 33, 35, 36, 39. Question.
What do you say family? Are we talking close family, extended family?
However you would define it.
Okay.
Okay. 24, 39, 40, 43, 44, 51, 53, 57, 58, 59, and 60.
Excuse me.
And 8. Now, keeping those in mind, those of you who raise your cards, because of that experience, are you able to put that aside and sit here and listen to the state and defense and solely judge this case? Or would you not be able to put it aside? Some people can't, and that's fine. We just need to know. Please raise your card if you would not be able to put aside that experience.
All right, in just one moment, let me pause it for a second. When she says put aside, for example, everybody carries around their experiences that they've had in life, right? Remember the incident where I was telling you if your car has been burglarized and then you're called down to be a potential jury on a car that's been burglarized? It's not really a matter of you forgetting your car has been burglarized. The only issue is whether or not you know your car has been burglarized. Would you be able to sit, listen to evidence that's presented in the burglary case and make a decision on that? So with her question, the question is, you have these experiences that you've had. If you're selected on this jury, will you be able to base a decision? If you can come to a decision, will you be able to base it on what you hear in this court for this specific case? That's what the fair and impartial is all about. Does everyone understand? All right, and you can re-ask your question.
Yeah, so go ahead and raise your card and say, I cannot be fair and impartial due to that. 1, 2, 4, 5, 7, 8, 10, 22, 24, 33, 35, 36, 39, 40, 51, 54, 60, and 74. Now, reverse, please raise your card if you or a close friend or family member have suffered sexual abuse. Raise your card. 1, 2, 3, 5, 7, 10, 17, 19, 21, 22, 24, 25.
I think it was 23, ma'am.
Oh, 23, sorry. 25, 26, 27, 28, 29, 32, 33, 34, 35, 36, 37, 38, 39, 40, 42, 43, 44, 45, 47, 48, 49, 51, 52, 53, 54, 55, 57, 58, 59, 60, 62, 64, 65, 66, 67, 72, 73, 74, and 75.
Question.
Yes.
As a middle school teacher, I have a lot of students that I am in some of this privileged information that I've been told about stuff that I don't know if that counts as friends and family.
It
If
counts
they're
if they're
students of-
telling you about it.
Yeah, the guidance counselors have
Some
clued me in on
mandated
certain
for-
things that have happened to some of my students throughout their childhood. So I guess I would.
Okay, so we'll count you as number 4.
I have a question.
Yes, 16.
Is sexual abuse and sexual assault the same thing, or is it two different things?
It could be the same thing, yes.
Okay, then I'm also included.
Okay, and that was 16?
Yes.
Now, same thing the judge went by. We all have our experience. What we are asking is, can you acknowledge your experience and sit and listen and be fair and impartial to both sides? It's fine if you can't, but once again, we just need to know that you cannot put aside these experiences and be fair and impartial. Please raise your card if you just cannot. 4, 2, 5, 7, 8, 10, 24, 27, 32, 33, 36, 38, 39, 40, 44, 45, 48, 51, 54, 55, 60, 62, 65, 66, and 72. All right, thank you. I'm almost done with my part. And
5 minutes.
I just have a question.
when you're asking the question if someone has been a victim, the reason I answered is I only have knowledge, hearsay. I've never talked to any of the parties. And so members of my family.
Oh.
So it's kind of hard for me to answer the question. I only just have
That
what I
one
heard.
story.
So does that count as?
It is if it's just you have knowledge, yeah. Would you be able to be fair and impartial knowing that that's allegedly gone on in your family?
Yes.
That's the big one. All right, so as Judge was talking about, and we'll do this briefly, she covered it mostly. So for the ag sexual assault of a child, it's 5 to life. The indecency is 2 to 20. It's up to a $10,000 fine, but you don't have to assess a fine if it makes it that far. It doesn't go to the victim or the alleged victim or anything. It just goes to like the court. And then only on the indecency are they technically eligible for probation. Now, keeping in mind, you guys know nothing about this. Every case is different. We're mostly just asking that you think of some possible set of facts, like in the multiverse, where it exists that you could conceivably give the minimum, or some possible set of facts you could conceivably give the maximum. You simply can't just make up your mind now saying, I'm never going to give, the max, I'm never going to give the minimum, I'm never going to consider anything but whatever number you have in your head.
And I'm sorry, counsel, and everyone, is just for you to acknowledge it, not give it. Can you consider the full range of punishment, not give the full range or give the minimum? Does everyone understand? All right, state.
Thank you, Judge. It's more just sitting there going, we convicted, the minimum's 5. Can I do that? Yes or no? And then you can move on. So here's more cards again. Number 1, I will keep an open mind and consider the full range. Again, you just have to consider. You don't have to say whether or not you give anything. Or number 2, I absolutely cannot consider the full range. I need you to raise your card if you're number 2. I absolutely cannot consider the full range. 2, 8, 22, 24, 39, 50, and 62. So raise your card if you're a number 1, then. I can keep an open mind and consider the full range. 1, 3, 6, 7, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 23, 25, 26, 27, 28, 29, 30, 31, 33, 34, 35, 37, 38, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 51, 52, 53, 56. Then we got 57 through 60, 61, 63, 64, 65 through 80, or through 68, 69 through 72, and 73 through 75. Alrighty, I'm about to hit my time limit, so I'm going to go ahead and pass it on over to defense.
All right, defense, are you ready to proceed? All right, you may proceed.
I was about to say good morning and I realized how late it was.
Mardi Gras.
Happy Mardi Gras. That's right. The good news for y'all is the judge and the state have gone over so much material with y'all. I don't have that much to talk about. I do have a little, so please bear with me. Let me start off with a pop quiz for you. As the judge said and talked about the presumption of innocence, the state talked about it. My client sits at the table. We were going to take a vote right now. Guilty or not guilty? How do you vote? Your choice is guilty. Your other choice is not guilty. How would you vote right now?
Not guilty.
Very good. Or listen. Has anybody here heard of someone who had a jury trial, was found guilty, were sentenced to punishment, and later were found to be not guilty? $50,000.
I'm sorry, if you could speak up.
I'm sorry.
Yeah.
I'm talking soccer. Number 28. What do you know about that?
I mean, I've heard like just seeing stuff, like hearsay more so about that, like someone being found guilty and then later finding out that they weren't guilty. It's more so just hearsay. Not anything I've experienced or like know anybody.
Sure. Number 35.
Black man. You know what I mean? Everybody knows black people get found guilty for BS. And then they're actually innocent.
Fair enough. Anybody else? Yes, ma'am. Number 43.
Suppose
Could you please
victim
stand up?
recanted.
Could you please stand up? I didn't hear you.
The supposed victim recanted because the parents put it in her that someone else had done wrong to her, even though it wasn't true.
Number what?
DNA evidence would prove somebody innocent. On the other hand, it also proves somebody guilty of being on.
Thank you. State brought up earlier, we were talking about children, whether they would either make a false accusation or deny. Do you all remember that conversation? What do you, why would someone make a false accusation? I'll start it that way. What do you think? Number 50.
Because they're mad at the other person,
That's right. Number 20, what's that?
because they're mad or they didn't get their way. One of them.
That's right.
They didn't receive the correct attention from that person?
I'm sorry, they didn't receive the correct
Attention?
attention? Very good. Number 9.
My parents got divorced when I was young. I was pressured by the lawyers on my father's side to make my testimony appear that my mother was wrong.
How did that make you feel?
I was compelled.
You were compelled to do it. You had no other option. Tough situation to be in. Anybody else?
I think someone in the back raised their card.
I was just gonna say, they feel pressured.
They felt pressured.
A lot of times you feel pressured. Parents can ask them questions and parents may not knowingly be giving them ideas, putting ideas in their head. But as parents, we also like to, get everything out of our kid. And sometimes we put that idea in.
Oh, that's true. I've got a 7-year-old myself. And I don't want to say he likes to bend the truth, but there are a few things that come up where it just look like, really, guy? I mean, come on.
They also have a big imagination.
Absolutely. Absolutely. Does anybody here know someone personally that was falsely accused? Yes, ma'am. Number 43.
Yes.
You do? Who was that?
My husband.
And I'm sorry, I should have, hang on one second, gentlemen. I should have prefaced this. If there is something that I bring up that might be a little too personal that you don't want to talk about in front of others, I apologize, man. Please raise your hand and let us know, and I'm sure we can talk about it. Okay. Gentlemen, number 62 and 61. Who did you know, sir?
Well, myself, civil suit lawsuit back in 2020.
Okay.
Beginning with COVID. I was involved in a multi-vehicle accident back in 2018. And so it wasn't until 2020 that I was surrendered with a, what you call that? A
Sign.
a subpoena? No, not subpoena, no.
A citation for a lawsuit?
Citation, yeah, lawsuit paperwork. And when I read the probably 10 pages, not only myself, but there were several others in that document being accused, wrongfully accused, right, of driving intoxicated, et cetera, et cetera. And when that wasn't the case.
Right.
So
Thank you for this. Number 61. My guys, we have number 73. Hang on one second. Yes, sir. 61, yes, sir. Same thing.
My cousin.
Your cousin. Yes, ma'am, number
I
73.
have a question. I thought it was, do we know someone who's been, or us, or someone who's been falsely accused of some sort of a sexual crime? Is it any crime? Then yes.
You do, and what would that be?
My spouse was basically framed by someone who was angry with him to say that he tried to physically assault them. He was vindicated of it.
Thank you. Is there anybody else?
It need to be something that was litigated.
It doesn't have to be litigated. I'm just asking if you know someone who's been falsely accused of anything.
Oh, yeah, absolutely.
Then you were number 47, number 55. Yes, sir.
Some neighbors down the street. Somebody accused them of having drugs. I'll come for dinner, shut their dog.
Along that line of questioning, would y'all say that it might be more common than not to see false accusations? How about this? Hold your cards up if you think it might be more common than not to see false accusations. It's more common than not to see or hear about false accusations. Number 3, number 10, 28, 33, 34, 35. You can lower your card if I say your number. 37, 38, 43, 50, 49, 51, 52, 53, 66, 68, 70, 72. Thank you.
I have a question.
Yes, ma'am.
Are you asking, like, is it more common than it's ever not been before? Like it's happening more often?
Yes.
Or are you like saying like people who are accused and guilty, it's more common people are accused and not guilty? Like what can you clarify your question?
I'm speaking more in terms of generalities.
Okay.
In other words, from everything in your life up to this point right now, sitting here, is it more common to see these false accusations?
So on any topic. Okay.
Any. Do you think lying is prevalent in society today?
Yes.
Everybody hold the cards up if you think it is. That's a lot. I'm not going to be responsible. So ultimately, we're going to have 12 of you picked. And there could be an alternate. For those of you picked, what are you going to look for to see if something's a false accusation? What do you think? Good. I'm sorry, who said that?
The truth.
The truth. Okay, anybody else? Yes, ma'am, number 22.
If the story changes, or if their testimony changes over time?
Okay.
Yeah.
Number 35, yes, sir.
Facts.
Facts. Facts. Number 4, yes, sir.
Conflicting witness statements.
Anybody else? Anybody have any thoughts on the matter?
Is this the hold your peace part? Is that what your question was?
Hold your peace, I don't know.
It says right there. Oh, is that like a, so then I do have a question.
All right, if you'll take that off the screen, please.
I'm sorry, I didn't even realize that was.
I was trying to follow along. So can I ask a question or
Absolutely.
it's a pseudo question?
Okay.
I got really uncomfortable with the discussions when it started talking about, can children lie? Are children apt to tell the truth? Are they apt to stretch the truth? My heart rate went up. My ears perked up. I'm a teacher. I have children come to me all the time and be vulnerable and say that things are happening to them. And that rhetoric that sends me over the edge. And so that's my piece.
And what was your number, ma'am? I'm sorry.
19.
Number 19. Thank you for that.
I said it earlier, but I'm a teacher as well, and I deal with a lot of the same things.
Sure.
Yeah.
I imagine you guys deal with a lot of stuff. I'm sure you have to take it home. I'm sorry, number 32. Yes, sir.
Yes, sometimes some lawyers can twist the truth. No, you're guilty, they can twist it around and make it look like he's innocent.
That's a fair statement, sir.
Yep, they can do that if you're not, sometimes they trick in your mind.
Okay, thank you for that. I've got just a little bit more and I'll be done, I promise. And the next two kind of tie together. We talk about biases, prejudices. Now, I think we hear it in the world, we hear about prejudice and we automatically think that's a bad thing. We don't want prejudice, right? I would tell you that I think everybody has a bias and a prejudice against something. Let me give you a very bland or generic version for myself. And I'm not talking about race, creed, or color, or sexual identity, or anything like that. Okay? You want to know one of my biggest bias and prejudices in life? I can't stand people drive in the left lane and they're going slower than the stupid speed. Okay, is there anyone who will agree with me?
Yeah.
Hallelujah, I have found people. What does that mean for me? Well, if somebody got a citation for driving too slow in the left lane, and they took that to a jury trial down in municipal court, which again, they have that right to, and I got called for jury duty, I can tell you, I would not be a good juror on that case. Okay? Because I can't stand that stuff. This case, a little bit different, obviously. Is there anyone here, and we've talked about it briefly, but is there anyone here that, if you think about it, they're not neutral? For those of you who had a stick shift and knew how to drive a stick shift, is there anyone in one gear or another saying, you know what? I'm not gonna start out fair. I'm gonna be leading one side or the other, whether state or defense. Please keep cards. Number 1, 2, 3, 4, 5, 6, 7. Number 8, 10. Right here on the front row, number 19, number 21, 22, 23, 24, 25, 27, 28. You can lower your cards. 28, number 30, 32, 33, 34, 35, 36, 37, 39, 44, 45, 46, 47, 48, 49, 51, 53, 54, 55, 60, 62, 65, 66, 67, 72, 74, and 75. Thank you. Is there anybody sitting here, again, that's sitting here and they've heard Allie talking, and listen to myself, and they say, you know what, John, this is not the case for me. I am not going to make a good choice. It's like mostly the same numbers, but let's go through them one more time. 1, 2, 3, 4, 5, 6, 7, 8, 10. 17, 22, 23, 24, 27, 36, 34. Going backwards, I apologize, 33, 32. 37, 39, 44 to 45, 48, 51, 53, 54, 55, 59, 60, 62, 65, 66, 67, 72, 74, 75. Is there anybody here sitting here and listening to me saying, you know what? John, I really wish you would have asked me this question. Is there anybody out there who thinks they need to speak up about something that we haven't talked about? Yes, sir. Number 61.
I've been involved as a juror on a typical case like this.
I'm sorry.
I was involved as a juror in a typical case.
Okay, so you have prior jury service on a case like this? Yeah. Okay, thank you. Was that, I'm sorry, was that here in Bear County?
Yes.
With Judge Boyd?
No.
Oh, you get in for a treat. You get picked on this. I'm sorry, number 5.
Yeah, yeah. You didn't ask like people who worked on task force to hunt, find these people. I was in the Army and that's what we did.
Okay, thank you very much.
So, yeah.
I think that's about all I've got. I thank you all for your time, your attention. I appreciate y'all being able to speak with us, honestly. Would ask for whoever does get selected, please don't do violence to your conscience. When you hear this case, keep an open mind. We appreciate your time. Thank you very much.
All right, so ladies and gentlemen, I'm gonna have you all step outside. Well, wait a minute, slow down, slow down. I have to give you instructions. So if you need to use the restroom, wherever you see the stairs, there's restrooms on either side of those stairways. So if you all are using the restroom and there's a long line, just either go up or down and you'll see a restroom on the side of the stairs. I'm going to ask you all to leave the numbers in the seat that you have. Those are very expensive. I'm going to have to ask you to take your personal items with you. And I'm going to have you all step outside. Everybody has to leave the courtroom together. And then we will bring you back in and let you know if you have been selected for the jury. So I'm going to bring you all back in no later than 4:40. Okay. All right, everyone, please rise for the jurors.
I'll call you out.
Why are you in trouble today?
Is it downstairs, Your Honor?
Downstairs in the basement.
Okay.
Mm-hmm.